I'm a patent attorney, and I'm the owner of Bold Patent Law. So it's a law firm. We're headquartered here in Seattle. We have 3 patent attorneys that are local here: James Bunce, Greg Dawson, and myself. We have attorneys in California and Chicago and Tampa, and we're growing. So it's really fun. We're being able to serve clients nationwide, and we love getting out and doing discussions like this with people like you that are out there, entrepreneurs making a difference in the world. Education is a big part of what we believe in, and making sure that we get information like this out to the public, because there's a lot of misinformation out there about patent law. You get kind of a lot of, let's say, armchair quarterbacks in this field, and people that hear lots of things from shows they watch, like on Shark Tank or Entrepreneur World or whatever it is that they hear, without actually getting the facts. And with the world, the internet we have, there's so much out there, and it's overwhelming. And so getting information from people that are in the profession, much like tax or any other type of insurance, it's important to get it from someone who does that for a living. So while I still come humbly before you as a person that's learning in the industry, it is what I've spent the past 5 years doing. So I hope to share with you what I've learned, and at least 2 big subject matters today. We're going to dive into patents and trade secrets. This is a special focus class. We did one early in January where it was covering all 4 areas of IP: patents, trademarks, copyrights, and trade secrets. So we're going to skip over copyrights and trademarks today. That'll be for a later session. Today we're just talking about innovation, and help yourself to as many of these as you want. So let's take a look. So this is part of a series, patents and trade secrets. We're going to dive in today. It's May 3rd, learning about the law. That's what we're talking about all day today. And because it's just 4 of us, it's going to be really interactive. So if you have any questions, stop me. We'll just pause and take a break and answer your question. I budgeted about a half hour of Q&A already, so it's free. Don't worry about knocking me off schedule. Next month, we're creating a plan. I mean, hopefully all at least thinking about, or maybe already starting a new business, in your moonlighting, or you're already on your way, putting IP, specifically patents and trade secrets, into your plan, how those actually fit in. And then last but not least, in July after the holiday, we'll be implementing those. So what are steps to take in the class? It'll be workshop style. We'll actually do some things in the class about how to do searches, how to identify trade secrets, how to begin classifying them. And so I'm interested to see, if we can get some people matriculating through the class, and then we only have 4 here today. Sometimes we'll get people joining in midway. It just makes it really fun. Thanks, sweetie. Okay, great. So the agenda, and we're a little behind snacks and all that. I'll ask just a brief around the room, just so we can kind of get familiar with who we are and what kind of industries we have represented. So if you I wouldn't mind first name, if you've got a business started already, the business name, and your industry. If you start over here, sir.
Sure. Nasser, and all sorts of different
things. Good.
Background in tech.
Okay.
I've since changed careers to massage therapy.
Awesome. Okay.
So there's a lot of innovative ideas dealing with the massage therapy trade.
In
terms of services side.
Okay.
How to deliver it,
how right.
To communicate in contact with the communities and expanding and whatnot.
Okay.
There's a lot of things there, and I have a couple of other pet projects, so to speak, very tech heavy.
Oh, okay. So separate from the massage practice. Okay, so you got a lot of things going, but that's the one major effort.
I'm committed to right now is the massage therapy side. There's a couple of business opportunities pertaining to just healthcare.
Okay.
Just process.
Good. And do you have a business up and running yet? Business name or anything yet?
I do for myself.
Okay, but not for the massage therapy business yet.
For the massage therapy.
Oh, you do? Okay. Do you want to share? And if not,
Bodywork Seattle.
Bodywork Seattle. Cool. Awesome, man. Thank you. So tech entrepreneur went to massage. Yeah, still innovating in that area. So excellent. Thanks for coming, Nasser. Okay, and next to him, Kanji. Okay. 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 Any specific problems being solved with your apps?
No, actually, we're building a client's project.
I see. So you're okay doing the developing of
Yeah.
several different types
Yeah,
of apps.
yeah.
Got it. You're the
So my
developer.
clientele is basically small business owners and other stations.
Okay, we should talk. I'm considering doing a legal app. Having some issues for this. Um, excellent. Well, it's just kind of bouncing. I don't know. I'll just kind of keep things moving with my mouse. That might work. And Keith. Ocean autonomy, marine piloting systems, autopilot. That is so cool. That is so cool. Do you have a name for that business? Ocean autonomy. Thank you. Okay. All right. And Keith. Perfect. All right. Nina. Okay. Medical diagnostic service. Any specific ailments or health issues in particular?
No, it's mostly around things that get built.
Okay. Well, for testing type of stuff. And do you have a business started, or it's just kind of at the very, very beginning stages?
Very
Okay. Thank you for sharing, Nina. Okay. Excellent. So we're going to go over the patent law fundamentals for the first part of the session. I'll try to keep us on track. And then we'll do a bit of a workshop just to test our understanding of that, and then dive into trade secret law, talk about how laws are enforced statewide and how there's a federal mandate and how to protect that through the Defend Trade Secret Act. We'll do a small workshop and then open it up for questions. Trade secret? I don't have any in slides information here. That is an interesting subject I could look into. I don't have anything prepared for that. Okay, so these are the 4 pillars of IP. For some of those that think hear intellectual property, this is what it means. There are a couple other smaller areas. I'll mention those, but patents is the one that comes to mind first when I think of intellectual property. This is inventions. These are designs and functional inventions, and they're protected by the U.S. Government. They give you a 20-year limited monopoly in exchange for you sharing your invention or how to make something work. Trademarks protect a brand, really more to do with protecting a business and making sure that the customer knows where they get their goods from. It's the source identifying. So brands, logos, that all falls underneath trademarks. Copyrights is more the right that protects creators, authors, singers, performers, all different kinds, right? Visual, sculptures. I mean, it covers a wide range of artistic creations. So that's the domain of copyright law. Trade secret is it's quite different than the rest, where you don't actually get a document or a federal right. It's more of a protection that you can get if you enforce it within your employment structure. So it really is all a part of being keeping things in your company in the right way and enforcing confidential information in the right way. And I'll go through what that means a little bit more. Privacy law actually does get tucked underneath intellectual property. And because privacy is such a big deal these days, we do a separate discussion on privacy, all around HIPAA and compliance around government compliance and terms and conditions. It does fall underneath intellectual property. Related to privacy is famous people and personalities. So it's a different classification, but it can be considered a part of IP as well. So as soon as someone has a famous of enough identity, they can then begin suing for things like defamation or slander. That all falls underneath intellectual property too. But these are the 4 main ones that we talked about so far with SURF here in the startup. So intellectual property, just wanted to get kind of a show around the room. Maybe anybody have a volunteer? How would you describe intellectual property if you had to? Someone asked you on the street.
I just say the description of an idea.
Description of an idea? Good, good. Anything else? Maybe a little more specific than that? Like where those ideas come from? Okay.
Creations made from a person or a company.
Okay, close. It doesn't have to be a company, right? Just from, you had it with person, from the human mind. That's it. That is really the definition of intellectual property. And what's nice, what I like to say, kind of add on to that, is that it's the legal protection, the legal framework that supports innovations that come from the human mind. Okay.
That would not include discovery if it's an
Correct. Yes, yes, and plant patents. So we'll get to plant patents. There are you do not get to get a patent for something you discover that comes from merely natural resources. You must be able to reproduce it in a lab setting, and so that's sort of plant patents. How do they get to name them?
Yeah, I mean, like, you have like a monopoly on a name and it's known as that thing.
Well, so that actually goes to scientific naming conventions. You name, I believe, the genus. I'm not a organic botanist, but there are ways to actually name like animal species and the animalia and the kingdoms and all that. But then, if you're going to go to market with a product, that would fall underneath trademark as opposed to patent law. Like you heard of the famous drugs, Xanax. Though that really has nothing to do with the actual drug. That's just more of a trademark. Yeah. Maybe that got to your question. Maybe it didn't.
Yeah, I'm wondering, like, you know, somebody maybe
Oh, I see. Oh, interesting. Yeah. Well, I'll have to come back to you on that one. That's good. So, okay, what is intellectual property? Why is it important? Why is it? Why do we care? Why are you guys here? Right. No, well, your first inclination is right. It's about the commercial success, right? It's part of bettering society through commerce, having that be the motivation, primary motivation to try to help the world become a better place. We want to reward innovation, and so that's why it's so important. Okay. Thank you for participation. So I wanted to bring it back a little bit to the Constitution. So believe it or not, this is a quote here from Article 1, Section 8. To promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive rights to their respective writings and discoveries. Okay, this provision was put in because at the time of the writing Constitution, there were these secret groups and societies that would keep information for long, long times, and they would produce products and mixtures, or they would sell things, and these groups would maintain this knowledge and not share. Right, this kind of these this not it wasn't productive, right? They wanted to, so in order to incentivize that information to get out there in the world for people to want to share their information, so that we all would be smarter, the government said, look, we'll go to bat for you, we'll protect you, we'll enforce your right, we're going to give you a 20-year limited monopoly to share this with everyone if if you were willing to tell everyone how to do it. So that's the reasoning behind patent law. So that's the first subject. Let's jump in. So patent law, at its heart, gives to the inventor. It's just this exchange, right? The government gives you this right, the ability to enforce, protect, prevent anyone else from making, using, selling, or importing into the U.S., right? Assuming we're just talking U.S. rights. There are certain international rights to talk about with patents for 20 years from the date of filing. So that's the exchange, right? So does it even qualify? This is one of the first topics we talk with when we talk with inventors. Is it even eligible under the patent laws? And so for utility inventions, these are the four main categories: machine, manufacture, process, which is what a lot of software falls into, or composition of matter, right? This would be chemical compositions or amalgam of metals, a new type of alloy. Machines is really anything that you can touch and feel, really any tangible device that has functionality. Those are the four utility eligibility functions. A manufacturer is more than one component, and it's fascinating to know that you can actually put together an assembly of parts that were already in the common art if they produce a unique outcome. So that's really it, is that if you had 4 widgets, all 4 of those had already been patented before, but you're putting them together in a unique way and them working as an assembly, what they produce is unique. That whole system and assembly is going to be unique and protectable. All right, so given that, even if you've come up with something that you think is, or that is eligible, right? It fits into one of those 4 buckets and is eligible, can you actually get through the patent office? Is the examiner going to say, okay, this is good enough, this meets the criteria? This is what you have to prove to the examiner. Novelty, right? This is worldwide novelty. You've got to be able to show and prove that what you've come up with is the first of its kind ever. And the examiners are privy to quite a bit of information, right? Not just the U.S. Patent Office, not whatever's been filed in the U.S. system, but anywhere in the world that's ever been published and translated into English language is findable. They also look at what's called non-patent literature, which is academic journals. Anything ever been published online. It could even cover things, on YouTube, Reddit, strange places that people have just discussed things or published them, whether on purpose or not. That could say, no, this has been done before, and they would cite that to reject your invention and the claims that you've cited. But let's say yours really is the first of its kind, and you're able to show that it's novel. You still got to get past this non-obviousness barrier. Non-obviousness is an insight that examiners will look at and say, okay, well, someone in the field of your industry, let's say you're a watchmaker, and you think you've got a new set of gears to put together this watch. But 2 years ago in the watchmaking magazine or the trade journal, there was a paper published that talked about how you could put a cog of this manner in with this type of a charger, but they didn't actually do it. And there was different types of materials that they listed in that publication. It would be an obvious attempt, right? It was discussed, but it wasn't actually ever done. It was just an obvious iteration of a different style. And so that'd be a perfect citation the examiner would use to say, no, this is just an obvious iteration, an obvious version of what's already out there in the art. So they look at what's available to that watchmaker. What are the publications? What is the knowledge base of that watchmaker, the watch inventor? What would they be privy to make that assessment? Utility is a fairly low bar, but it does exist. So this means, does the invention actually have real life functionality today? Does it provide any real function today? And like 99% of inventions pass this bar. Sometimes you get caught up in this issue where there's no real life application in today. It's like a futuristic application, or it's hypothetical. This does come into play a lot of times with drugs, where they claim to, for example, lower cholesterol. And utility is the biggest bar to get past because they have to prove that it actually does lower cholesterol, right? Or that the algorithm does actually reduce the RAM, or the amount of electricity output, whatever it is that's being claimed. For most other things, it's not required, but certainly for claims that are sort of require proving it, utility can become a bar. But most, it's not a big deal. Okay, so those two last slides talked mostly about utility patents, and that's what makes up about 80% of all patents that are issued today. They have to meet those requirements. Design patents they're not about functionality. Design only covers what something looks like, and just the pure ornamental appearance of it. So that's what a design patent is. It doesn't have to prove any function or do anything. It's just merely what it looks like. And we talked briefly about plant patents. Plant patents are where you actually have to provide a specimen to the examiners, and you show that you've been able to asexually reproduce this plant. You can down to the chemical breakdown. You have to provide the actual example so they can see that it actually is a unique strain of whatever it is that you're producing. Right? Common plant patents are those in hops or apples or flowers. Pineapples, all different kinds of things, and you can actually get a patent and have be the only one that could ever produce that or make, use, sell, or import. There's recent law changes in patent law. American Invents Act was passed in 2013. A few years back, it's still kind of coming through and getting implemented as patents are now being issued that filed in 2013. They take a few years to get issued, and so we're seeing some interesting things happen. For one, the examiners are now privy to the world of all prior art, whereas before they were just looked at the U.S. Okay, and after the AIA got passed, they instituted this brand new panel called the PTAB, It's a patent trial and appeal board. It's a special Article 3 court where judges all day long, all they hear is patent cases. And so they hear invalidity claims, and they also will hear reissue attempts. So if you're a patent holder and you're seeking to enforce your rights on someone you think is infringing, you take, like say I'm suing Microsoft. One of the first things that Microsoft would do is they say, no, they're going to try to invalidate my patent. Before it even goes to federal court, they're going to want to take it to PTAB and make sure that the claims I'm asserting against them are actually valid. It's sort of, I think it's a sad thing, but it's true that even if the examiner and the patent office says, yep, here's your patent, it can actually later become invalidated, right? Either because a mistake an examiner made or because the law has changed. So it's one of those things like I kind of wish it wasn't the case that could happen, right? You get these rights, you're kind of cleared, you've got the ability to prevent anyone else in the world from doing this, and the law can totally change underneath you. And that's what happened with the AIA is that, not with the AIA, but I'll talk later about a big case about software, where tons of software patents have been invalidated for the past 3 to 4 years because they've been decided to be abstract. All right, merely algorithms. There were just a sloth of them that were issued in the late 90s and the early 2000s around commercial transactions, around things that are just really more equation-based, databases, just doing what we already did with traditional calculators and pen and paper, but just on the computer. And the judges since then have said, no, those are invalid. So a lot of money had kind of been wasted in getting those rights because the law really wasn't clear, and it did change. The biggest change in the AIA, I missed the first bullet point, was that before 2013, inventors could before then used to come out of the woodworks. An application would get filed on a new rocket propulsion system, and you'd get 3 or 4 inventors saying, no, I invented this first. Here's my notebook. No, here's my notebook. I got it signed by my professor and certified. And there were these interference proceedings that where they argue about who invented first. And it's a mess, terrible mess, you can imagine. So we're going to save a bunch of money. It's actually about who files first. It doesn't matter who actually independently invented it first. It's who gets it filed. So it's a large impetus and a large wave of new filings because of this. They want you to have, create some urgency. They don't want you sitting around spinning your wheels in some lab. They want you to get it out to the world and publish it quicker. So that's the big push there. So with timing, yeah. No. The only way you can get rights back today is if you can show that you disclosed your invention to party B, and party B then filed it fraudulently, saying that they were the inventor, right? If you can prove that they derived it from you, there's a derivation proceeding now in the front of the PTAB. So that's why it's very important for all inventors to document whoever they've disclosed their invention to. And you should certainly do it under a valid contractual non-disclosure agreement if you have to. But I advise my clients to file before even disclosing to third parties, just to make sure, because it's that important. And you can file a provisional and get the whole year that a provisional can provide in order to then disclose to investors, third parties, bring members on, do Kickstarter, whatever you want to do, right? Any other questions around that? Okay, I'm just kind of moving quickly because of the time here. So statutory bars are really important. And we talked about disclosures just now, but if you share your invention to anybody from the public, right, without any air of confidentiality or not under an NDA, that starts a 1-year window. And yeah, go ahead, man. Help yourself. And that after that 1 year is up, you have dedicated your invention to the public. That window also starts if you put it up for sale. Even just offering your invention for sale begins that window. And in a recent case just this year, it was decided that even a secret sale offering starts that window. So, right, even if you're under NDA making an offer to sell your invention, that starts a 1-year window for statutory bar. So if you're in that window and you're worried about timing, come chat with me later. We can talk about your specific scenario. And one caution with non-disclosure agreements, you got to make sure that all contracting parties are going to be bound to that. So who is in the agreement, right? Are you contracting overseas? You got to make sure that contract is going to be binding with the other party's legal system. That's a huge endeavor. Even within the states, different states have different rules about contracts. So make sure you're working with an attorney to make sure it's going to be a binding non-disclosure agreement. Hey, welcome. So, all right. So, say you've worked so hard, you've got all the way through the system, and you've finally got your patent issued. What happens if someone infringes it? So these are the kind of the whole steps of the process. And you want to try to get through?
Oh, no.
Okay. For most cases, when we get approached by someone who says, "Hey, I found someone who infringed my patent. Let's go get them." We say, "Okay, hold on. Hold on." That's your first kind of emotional response is, to go sue and go try to enforce your rights. It's important to do the homework first and be proactive instead of being called out on these steps. So the first step is doing a validity opinion. So what we do is make sure that those claims you've gotten, by the way, claims are the heart of a patent. We'll get to that, I think, in a little bit. So claims are basically what you're, in words, saying what you own. We want to make sure that those would hold up in a court if they were brought, given the current law. Right? We just talked about the difference. I think cracking it would be good. Yeah, a couple inches. Yeah, thanks, son. So, like I said before about those software patents, right? The laws can change on you. So you want to make sure you work with an attorney and know that your invention is valid before you go enforce it and go write a nasty letter, take someone to court. You don't want to get trumped and have to be reactive. Second is an actual infringement opinion, right? So it may actually look like they've got the same product as you, they're just ripping you off, but you got to take a closer look at what your patent claims say. You might have these really nice visuals and designs, and you may have a nice broad specification outlining how your invention works. But as it happens, when you go through the patent office, the examiner usually makes a lot of rejections, and you've got to usually limit your claims, and your claims end up changing, and almost always smaller than what you think they really are. When you read all those words, the more words there are, that actually means the less scope you have in terms of breadth of claims, what rights you really own. And even though your invention might be on a new car, well, your claims say you've got a unique fender, right? A unique fender with a certain bend and a airfoil. That's it. And this other guy might be selling something completely different. So you got to make sure you do an infringement analysis, infringement opinion. So let's say you get through those wickets and hey, your claims look valid, and sure enough, it looks like someone's infringing your claims. You usually want to you send over a cease and desist letter. And this may be, we sometimes even put a little step in between there. And I like to have the owner try to just reach out, right, to the infringing party, just non-attorney to non-attorney, because that sometimes a lot gets done without attorneys, I've found. And if you can get to a cordial, get to your goal, whether it be to stop them from producing or to have them come to a settlement, things can get of course, a lot cheaper for everyone involved. But if things aren't working out, there's no communication, they don't really, they kind of give you the middle finger and say, whatever, man, then you need to step up and hire an attorney to send a cease and desist letter, which in essence says, we demand you to not only stop, but pay damages based on the sales you've had from this and this time, and outlines in very clear detail how they're infringing on your claims. And it's a very threatening, very serious letter that's meant to scare them, and you do threaten litigation. That's what it says. So assuming you get their attention, the goal then would be to go to settlement, which is a win in most cases, right? As a patent holder, especially if you haven't yet built up your business, you've just got the technology, and you actually may have a business partner, someone that's already building a product, already in the stream of commerce. Why not think of them as a business partner and look to get a royalty, right, on every product they sell? Because usually is a nice shining, sort of a silver lining to a lot of this in reaching settlement. If you can't get there, go to an arbiter. Then we go to litigation, and like I mentioned, the PTAB is a common place where patents get litigated. It's a lot less expensive at the PTAB because those judges are knowledgeable about the law, right? Things take less time. These judges hear patents all day long, so it's really the attorneys and the clients, they know what to expect when they go to the PTAB. Federal court is sort of the last resort. Right? Going to trial is very, very expensive. Tons of discovery, experts. Minimum you're looking at $200,000 or $300,000 to take it all the way through to verdict on most technology. A different venue you can go to is the ITC, International Trade Control. Okay, so this is an avenue to go down if you're not necessarily interested in monetary damages. Okay, you just want to get someone to stop shipping into the U.S. That's what this is for. And what's interesting about the ITC is they will not stay the hearing for a PTAB concurrent proceeding. So sometimes, like I gave an example earlier where you've got, I've got a patent and I'm suing Microsoft. One of the first moves they might make is to go sue you, go take you to the PTAB to go try to invalidate your claims. If you have a co-pending federal case against them, the court, the district court will say, no, I'm going to wait. I'm going to hear what the PTAB says first before I continue. The ITC, they'll go ahead without waiting until you get a nice fast response. You'll get the customs to basically stop shipment a lot quicker, but it's expensive and there's some different pros and cons there. But like I said, there's no monetary damages that come out of the ITC. So if you want money damages, you got to go to either federal court or to PTAB to invalidate. Okay. So long list of things that are required to file an application. I'm not going to go through every single one of these. I want to just highlight the 3 that are required to get a filing date. This is for a patent application, a non-provisional patent application. So while you do have to submit all this stuff eventually, to get that all-important filing date, you just have to file a specification, claims, and drawings. So a specification is a fancy word for a written description of your invention. And drawings are needed if it's, for almost every case you need drawings. But the requirement is to have claims. Okay, so claims are the heart of the patent. This is what defines your rights and what you're saying you've invented and what you own. So those are the 3 that are required in order to get there. The spec has to be enabled. So it's a fancy word that just means you must fully describe it such that someone like yourself, an inventor in your field, will be able to take that writing and go build the invention. Go make at least one version of your invention. That's how detailed it's got to be. So here's as compact as I can get it, sort of an ABC flow chart for for filing an application. And we meet with our clients, we go through eligibility. We talked about, hey, is this even fit? Are we even in the right game? Is this one of those 4 types of patents? Is it a machine, an assembly, a process, or a composition of matter? Are they the only inventor? Sometimes it's the case you got multiple inventors. So make sure you understand who's inventing this thing. And oftentimes we end up talking with a lot of employees of businesses that are actually going to be the owner of the invention. A lot of folks don't understand that when they invent and they're on the job, an invention likely is owned by the company that they work for under their employment agreement. So those are all things you can get upfront and clear about who the client really is and what the expectations are for the business. A lot of inventors, it's key to understand where their mind is, what their goals are. Whether their goal is to just be a technologist and just come up with the new technology and license and sell it, or if they want to grow a business. So it's important to understand the goals so we can help advise and give recommendations either way, right? Forming an entity, getting an operating agreement together, helping you with investment, or just looking for licensees and buyers. And so the big choices here after you do a patentability search is to file a provisional or a non-provisional application. There's in most cases a new inventor, someone that's doing it for the first time, we almost always recommend filing a provisional. We do this because it's a nice place to get the filing date, you get the patent pending status, and you don't lock yourself into claims right away. And you have all the way up to 1 year to file. When you file that provisional, you've got a full year to then file your non-provisional. And so in that year, we recommend taking it to market, taking it to those people that might be interested in purchasing it, build the prototypes, take it to trade shows, test the market. To make sure this is something you really want to go after. Check in and see if it's something you still want to do. And if it is, we'll go ahead and write the non-provisional, roll up any improvements that have been made in that 9 to 10 months, write the claims at that point. And it's the strongest way to get that submitted. All right, so, just trying to move quickly through this because we got a little bit of a late start. But for you guys that came in, you can just stop me if you want, ask questions as we go. Mm-hmm. Sure. Yes. Yeah, there are CFR 35 CFR 1.84. I'm going to write it down, but that's the guideline. There's actually a lot, and we have someone in house that's all they do all day long is patent drawings. They have to be line drawings at the non-provisional phase, and they must not have, like three-dimensional shading. You have to actually show in specific lines where the curves are happening, and most essentially, you have to point out the different elements that you're claiming. So the whole point of drawings is to be able to show the examiner, show the public, enable someone like you to actually go build the thing. So to as much as they're needed to be able to produce the invention, to be able to make it, that's how clear you need to be. For a lot of software and process patents, they're flowcharts. That's all the drawings are, right? There's nothing to physically show, and you would never want to put code or any kind of, unless you're trying to claim a novel graphic user interface, you wouldn't want to show that. Likely want to keep that as a trade secret. So hopefully that got to your question. Great. Yes. Mm. Yes.
Why even they have a patent, they can't protect themselves. So how can they?
Yeah, well, there's a big market for that in what's called litigation, finance, and licensing support. Say I'm a brand new startup and I actually work hard for 2 or 3 years, get my invention patented, have granted rights, and yet I see Amazon or Google or Facebook infringing. And you say, look, I don't have enough money. I can't do this. Well, you can actually license your right to a bigger entity, right? Sell your patent rights to someone that could go take them on. So it creates a market. You get to broker.
My question is, the thing is, the new startup
Mm.
after they publish about 2 months ago some sects give up the same product.
Yep.
And then trying to get the lawsuit with some sect they can't afford.
Right. Well, and what's nice about the patent law is that when you file an application, it doesn't get published for 18 months. Okay, so you do have some time, and that's with a lot of things in technology, fast-moving technology. You've got to be quick to market. So before you publish, before you even file an app, you need to be doing a lot of work to build the prototype up in-house and keeping things as trade secret before you publish them. So we advise clients very carefully if they're doing like an investor pitch, pre-filing. I advise not at all. If you can get at least a document, enough to get a patent filed first, do it. File it first before disclosing anything. And there's nothing to really stop, this issue of while you're pending. So even after it gets published, it could be pending for a year. And companies could take the risk. These big companies, right? They could say, there it is, great idea, I'm going to go do it. And kind of bet against you, hoping that you don't actually make it through and get the patent granted. We do that all the time. We'll send out letters saying, look, no, our client has patent pending invention that covers this technology. We're putting you on notice that when patents do grant, we'll be able to sue you for retroactive damages to the point all the way back to when they first got notice. So there's some methods to do that, but sure, there's risks, and happy to talk with you about a specific scenario if you have questions. All right, so how do you make money? So we talked about some of that right here. Okay, so when you have a patent that's granted, it's like any other property, right? It's like a your deed to the house or your ownership to a car. You've got the ability to fully transfer that. You can devise it through a will. You can decide to sell it outright, and you can license parts of it. You've got 4 main rights, and I mentioned these: the right to make it, the right to use it, the right to import it, and the right to make, use, sell. The right to make, use, sell, and import it. And so you could license just one of those, right? You can line up a manufacturer and give them a license to make it. You're the only manufacturer that gets to make this product for me. And so that's the ability for you to obviously get money, or you get money back for being able to do that. Someone's able to sell it on your behalf, right? They're going to want it. They're going to pay you a royalty for that license. You can litigate. Okay, so this is sort of a way to monetize, and this is sort of classic patent troll, non-patent and non-practicing entity type stuff, right? So you buy patent assets and you just litigate, right? And you look to try to threaten people and try to get them to settle or give you a royalty because of your rights. And the one nice side about patent trolls is that the inventor who sold, they got paid, right? So the knowledge got out to the world, and the inventor got paid. So in the end, there is still a good side to these patent trolls that get a bad rap. Competitive advantage, this is a good one, right? So if you've done your job and you've enforced your rights, you've kept competitors out of your niche, you have a nice broad portfolio of patents, you've got a market corner, right? You're the only person that can sell that one or two products or that service. So it's a big way to make money. The PTAB I mentioned is just a different form of litigation and federal court too. Just to show you some numbers, this is kind of fun facts. This is about a year or two old, but just to see, okay, who's out there selling? So Mitsubishi actually is by far and away the most active seller of patents. Okay, they actually sold, this is just in one quarter, 166 patents. So this is individual granted patents. Most of them are overseas, but 42 of them are US. A lot of other companies here you can see in electronics, computer science, and some universities get involved. So package just means more than one patent, right? Bundled together. Just want to show you some idea of how much volume, right? This is now who's buying patents. And speaking of patent trolls, so these guys are real local, right? Mercer Island, Intellectual Ventures. These guys purchase an enormous quantity of patents and put together portfolios. But they're not alone. There's a lot of other companies. I had never heard of these before I pulled this up that are purchasing. And this is just, again, this is in just a 3-month period of time. Data's that published. So there's a whole market out there for people willing to purchase patents. Now, how much do they go for? This is interesting to find out that the U.S. patents are generally worth quite a bit more, 30 to 40% more than non-U.S. patent assets. But I'm surprised actually about how low a value. But I mean, this is sort of in the grand scheme, and this goes along with being big portfolios of 10 or 20 patents being sold at a discount. Per asset, they're being sold for around $200,000 to $250,000. Okay. Well, I mean, the U.S. market is still very strong. The economic market, the economic upswing. Whoops. That's my guess. Is that? Oh man, Vince? I don't know. I think it just kind of spools and then we'll let it go. Yeah, that's my guess. Is that U.S. market's better just for people, selling, and then perhaps they believe that those patents issued are stronger. They believe in the examination that was done. All right, let's do a little workshop. So I know some of you guys came in late, but let's give this a shot. So I'll give you a couple minutes to read through this hypothetical, and then we'll come back in a couple minutes, and I'll ask for you guys to volunteer. So Sammy takes his invention to a trade show on January 10th, 2017. People love it. They fall in love, but he doesn't sell any. Okay? He just takes it there, tells people about it. He makes some improvements to his invention after the trade show. And he files his provisional January 20th, 2018. When should he file the non-provisional? And why do you say that? Okay. Anybody else see anything here? So finish what you're saying. So you're saying it's too late. Okay. Say what? Yeah. Yeah. Okay. Good. Anybody find anything else in here? There's a couple. There's one other big thing I'm looking for. He didn't sell any. No. He didn't sell it at all. He didn't sell any. He took it to the trade show. He publicized it. Beautiful. There it is. So that was the catch. So a couple things we hit on. So the sale part was sort of the red herring. That's the just because he didn't sell any doesn't matter, right? He published it to the public on January 10th. And so he has only 1 year to file a non-provisional on what he published. But the subtle catch was the improvements. is that if he did not publish those improvements, he could actually file on those improvements. Okay, so he would have time, assuming that, of course, he didn't publish those improvements. So that was the one subtle catch I wanted to point out there. So some people get into this issue where, oh my gosh, this has been on Kickstarter for 2 years, but they've been tweaking it, right? They've been actually modifying it quite a bit, and they have a whole different version than what's been published. You can potentially file on that new version that you've been keeping in-house. So you're not totally gone. Okay, well, yeah. Say again, sorry. Okay. I think well, so I guess I'll just say, hopefully I get it right. So you have invention A is the core invention, and you're saying that got published and you didn't protect it? It got protected by you. But it was published and you're not, okay, and a year has gone by? Uh-huh.
What he means is the thing you put in the market is not the same with the original design because you made improvement, but it still works because the patent was on original design. Yeah, that's what he means. So the product in the market is not the same with our original design. There are always improvements that people do. You can come up with invention, but then you start making it, trying to push it to the market, and you see there are small details that need improvement, and it's some going wrong.
Okay. Okay. Man, I don't know why. Maybe it's just late in the day. I'm not following you. So I don't know. All I got to say is that if whatever has not been published to the public, you can seek patent protection for. Yeah. Yeah. So if there's something already out there that has a patent, right? You can definitely get a patent for just an improvement on that. Now, but you have to pass the. Yes, and so absolutely, and most patents that get issued today are improvements on current technology. Absolutely, but the issue is that you're going to need to likely seek a license from that patent holder if it's not you to be able to take it to market, right? So there's a patent on a new grill for a BMW, right? This brand new grill, and you've come up with a way to actually make it more aerodynamic. So you've added this additional sealant, and you've got a system for putting on an airfoil and little vortices to break off the air wind current. Well, but it only is able to be added to this grill, right? And Mercedes has a patent on the grill. You're not going to be able to market and sell your improved grill without getting a license from Mercedes. Okay. Okay. Yeah. Your own design. Yeah. Okay. Yes. So in that case, in order to get no, you don't need that. But actually, what happens sometimes is the examiners will cite your own invention against you. You have to be able to show, even for improvements, that they're novel and non-obvious, above and beyond the prior art. We've had this before. Our own clients, right? They've got little changes to their invention, and the examiners say, "No, this is just an obvious change, an obvious variant of your original invention." So, yeah. So that is normally the problem. Anything else on patent law? We'll move on to trade secret. My watch is broken. Do you have the time? Okay, no, we're doing pretty good. We'll try to leave some time for Q&A. So trade secret, right? You see some really famous examples of trade secrets. The Colonel's recipe and Coca-Cola's secret recipe for their formula for the drink. So these are things that are kept within the company with the primary reason that they believe that it's not reverse engineerable, right? They're selling a product, and they don't think, no matter what you do, you can't figure out how to make this.
So this is based on taste. How do they
You don't.
The brand still
Yeah,
trademark,
yeah,
but there's the KFC's recipe, right?
yeah.
Patented.
No, it's a trade secret. That's what we're talking about. Trade secret. These folks decided not to patent.
Okay.
110 years ago, Coca-Cola decided, we don't think anybody can figure this out. And so we're going to keep this as a trade secret.
Airplane engines.
Okay?
There's only 4 countries in this world own the secret how to build airplane engines, and all of them patented because they don't want any other countries to build airplane engines themselves. No, they don't want anyone to have airplane so they can buy airplane from them. So they don't patent. They don't patent at all. So for other countries, you need to develop air engine by yourself. So you buy them from the countries.
Pratt & Whitney and GE, they have thousands of patents on jet engines. Oh my gosh. Yes. Yeah, I've seen them. I worked at Boeing for 10 years. I didn't work in propulsion, but I've seen plenty of patents on actual propulsion devices and fans and blades. Now, yeah. So tell me, so you're worried about yes, absolutely, absolutely. Yeah, and so that's the idea. Is that that's the big test before you decide to patent something. If you can truly, convince yourself that once it hits the market, that people could not be able to break it apart, buy it and figure out how to do it on their own. If they could do that, you'd want to seek patent protection for it. So, yeah.
What was the matrix thing on that?
So trade secrets are, this is kind of like source code. Source code is trade secret, and in almost every case, you wants to keep that within the company. Only if you ever wanted to start selling it or licensing software, would you then want to seek copyright protection for code. Right? Code itself is just like a book, like a story. A story can be told a million different ways, just like code can be written a million different ways. So you keep that under copyright law. So we have a whole separate section. We talked about copyright law and software, just like you would any other written language. But this is something you want to keep in-house and under top secret. So what's the overall premise? Is that things that are not readily ascertainable, in order to qualify as a trade secret, it can't be part of the public knowledge. All right. Now, it doesn't mean that nobody knows. Right? Maybe some people know exactly what goes into KFC recipe and they don't know it. Okay, but it must not be readily ascertainable, readily known in the public. That's one of the big ones. Okay, you've got to show that you're keeping it secret. So if it's a written piece of paper, you've got it in a safe and it's locked. A limited number of people actually have the key. Or if it's in digital form, it's fully encrypted, it's in the cloud, and only a limited number of people have access to it, and you're monitoring access to that. If it's a building, you're building a machine, you have a process, that's trade secret. You have badges, and you've got credentials and security. That's the element number 2, that you're showing that you're keeping it secret, going through efforts to show secrecy. And the third one is it must be economically valuable. Demonstrate to a court that your trade secret, if it got in the hands of a competitor, they'd be able to put it to immediate use to make money. So if those 3 elements are met, right, not known in the public, that you are keeping it secret, and that it's valuable, you've got a trade secret. So you kind of think, wow, okay, that could mean a lot of things, and you're right. Things like customer lists are trade secret, right? All of a sudden, your internal business processes become trade secret. And so it's really amazing how much actually is trade secret, how you do what you do in your business. I bet even surf, right? But you guys have ways in which you have positioned this office or this room, and those are different ways you might consider who has access to that information, right? And so it really is a lot about employment controls, and we'll get into a little bit of that here too. All right, so people ask, okay, how do I know, do I have a trade secret? And it's likely, yes. If you have a company and it's making money, you likely do. Okay, but I mentioned this, not readily ascertainable, efforts to keep secret, and economically valuable. So what can they be? There's a lot of things. Like at Boeing, we would have access. Some people would have access to our composite lab, and that's where a lot of trade secrets are housed. Boeing made a decision, for example, that they did not want to seek patent protection for certain methods of manufacturing. It's a really common thing to keep as a trade secret. mainly because of enforceability issues. So if you have a novel way to produce something and it's going to only be within your buildings, how on earth would you be able to tell if someone else is doing it without being inside their buildings? So it's another kind of way to look at something as well. Okay, even if I got a patent on this, how would I be able to monitor? I've got to be able to tell if someone's infringing. And if I can't tell from the final product, right? If I look at this chair and I can't tell if they used my foam producing method or not, just by the way it's shaped, even if I open it up, I can't quite tell if they used my foam manufacturer. I need to keep that as a trade secret. That's a secret in-house mechanism. So a lot of it's about monitoring and being able to enforce it later. Software is a huge one. So the software and source code is definitely trade secret. And formula is the same thing. Just like Coca-Cola, I guess, could be considered a formula. So these are big points that kind of go beyond IP law, but I just wanted to mention them here because they do vary state by state when it comes to employment agreements. And so each state has their own laws about certain disclosure, certain limitations that employers can put on employees for non-compete agreements, right? Sometimes you'll sign agreements. Washington is allowable, right? You could be signing an employment agreement that says even after you leave, you can't start a competing company for 6 months, right? This is not uncommon, especially in tech world. But in California, they're invalid, right? They want to have much more competition down in California. So every state's different. Non-disclosure agreements are the same way, right? Each state has their own rules around what does confidential information mean. There's a whole bailiwick of stuff to get into with regard to privacy and HIPAA information. Exit interviews are a great point to bring this up. If you're an employer and you have employees, this is huge. You want to make sure that as part of that severance package that they're getting, or you're giving them money, they're confirming that they're leaving information behind, that they're not, that in writing they say and reaffirm that they are not to take this confidential information from your company. And that way you really document that, and you'd be wise, especially if they're higher ups in the company or have a lot of experience. Watch where they're going, right? Just be knowledgeable, and you can actually inform their next employer just to put them on notice. Hey, we have certain trade secrets, and we want to make sure that you acknowledge, and without telling what the secrets are, of course, we want to make sure you would respect the fact that this employee has certain knowledge, and you wouldn't want to misappropriate that. Now, would you? And by doing that, you might scare them enough to make sure that that employee does follow that. Yeah.
On the exit interview, you want to decide, okay, what if they say no? You already have all the NDAs and everything before the final paperwork is just a scare tactic.
Yeah, it is, and well, a lot of times it's part of the bigger employment law concerns. There's oftentimes employment package, and I'm not an employment attorney, but a lot of times there's certain back pay or reasons where you're going to have to put an outlay of money out anyway. That's when you want to put that, even if it's not a severance package. But it's just if they didn't sign that agreement, they actually wouldn't get their benefits. I hope that answers a little bit. But yeah, it's a little complicated when it comes to that. If they didn't sign, it might mean that they lose, that they're kind of waiving their rights to other privileges. But the underlying point is that they're still obligated to keep that information confidential. It's just a not really good opportunity to again get it in writing if ever they were to misappropriate. So yeah, sorry, I don't have a much better answer to that. So computing security is a really big one. I mentioned the virtual workspace. I mean, it's becoming more and more prevalent. This is huge. It's harder and harder to watch employees. They're not always sitting in the cubicle, right? They're all over the world. They're all over the country, and so making sure you can monitor the access, even really closely monitor where the information is going. For our law firm, for example, like no attorney is allowed to save any information to their personal computer at all, ever. Everything stays on the cloud. That's just one example. I'm not a security expert, but from what I've been trained to do, that is the best way to know exactly where all of our data is. It's either on the cloud or not at all. So it's, in my mind, more secure to have it done that way. Now, a physical office, obviously, you want to make sure there's protections, like I said, badging in and out, protections around locking devices. If things are being stored on computers, you want to make sure they're not going to get just walked out the building. They've got monitors on them or whatever it is to track them. Those are ways to keep the office secure. Any questions on that?
It's less likely that small teams would have always secure physical office security.
Sure.
So it's going to be like a distributed, mostly team
Sure.
environment, and you would have to trust that people would be using correctly information. I mean, technically it's possible to copy from cloud anything and then use way
Yep.
store it locally. So it's not a problem. Save something from cloud.
Sure.
Windows is having in place the patterns. Does it and kind of publishing,
Mhm.
letting know that we have patterns? Can it be a deterrent from using this information in some other way by employees?
Oh, like telling your employees that you've got patented product?
We have patterns and information is protected, so there is no use of copying this information and then kind of trying secretly to use it or sell it.
Oh, interesting. Yeah.
Elsewhere after leaving.
Yeah, I would just say being as honest as you can. I think telling them everything, the whole story. If you have patented technology, they should know that. They will, you'll want to make sure that if it's trade secret, then you make sure that as part of your employment agreement before you even bring them on, that employment agreement has confidentiality provisions that's specific to the technology that you're wanting to protect, and before you give them access to that information, that they fully signed, and that's a binding agreement, right? And so if you're afraid of them, taking that information away, you've that even more reason to have that agreement in place first before you bring them on. And another clarification there: a lot of times people get confused. There are different rules about independent contractors and employees. There are different rules in place, and so there's stronger. So there's more. It's easier to get enforceability for employees because they have to have certain domiciliary, and because you're paying for their oftentimes their training and their hourly wage, you've got you've got the upper hand in terms of what access they have, tools and training. Independent contractors, it'd be tougher to put restrictions on it if that contract weren't already in place. Yeah.
What if you own a trade secret
Mm-hmm.
and someone knows it but patent it? So how can you solve it?
You're out of luck. You lose your trade secret. Yeah, and that's what's unique about trade secrets is that they don't have to be novel, right? Two companies could actually have the same trade secret, and if whenever they become known in the public, they lose their trade secret status.
That you have nothing to go get it back.
You have no way to enforce misappropriation,
You can't
right?
talk about payback.
Exactly, and remember, don't forget the trades. You don't get rights like you do for a patent for a trade. You just have the ability to sue for misappropriation if you can show those three elements. So you're not able to show that it's not readily known in the public. You're not able to show, for example, that it's economically valuable, whatever the reason may be. Then you lose the rights, right? Now, a lot of companies, what they do is they'll have these trade secrets in-house as they create prototypes and as they work on products. They don't publish them, but they keep it in these labs. And only when they reach a certain point, they file a patent, or if the timing's right. But they keep them under wraps until they feel like they're ready to be commercialized. But they're taking the risk that no one else will innovate on that same area and take it to the public. There's actually another little interesting wrinkle there is that a lot of companies like IBM are really well known for this and doing what's called defensive publications. And so they'll know that a competitor is working, perhaps. They'll have a good idea. A competitor is working in a certain area, and they've got enough resources and money to be able to actually innovate and publish new technology just in the form of a white paper in an academic publication to where that will prevent anyone else, their competitor, from getting a patent on it, right? So it's like, wow, my gosh. So they're being really aggressive, right? They're trying to block out anyone else from even innovating in a future area that could potentially compete with them. So it's an advanced way to do it, a way of providing the public with knowledge. So it still provides a general good. It still meets the kind of the sniff test. The really big case you guys might have heard in the news, Waymo versus Uber. So these self-driving cars right down in Silicon Valley. So it's a huge case. Oh man, this computer keeps doing this. But ex-employee, Wally was an employee at Waymo, which is Google's, Alphabet's company, Google, Waymo, self-driving car. He was a chief engineer. Just idiotic move. Downloaded 14,000 documents from Waymo's database, probably off their cloud, and within a week left the company. Okay, that's a red flag. And within a month started his own company, autonomous car, and then magically that company got bought by Uber, a competitor in very much the same field. So long story short, saving you some details. If you want to go dig in, please do that. It was going to go to trial. All the attorneys were waiting. We wanted to get a ruling on this. We wanted to hear what the judges had to say about trade secrets. And they even had it all calendared and everything. But it settled. Okay, it settled. But for a big number, $245 million. Huge win for Waymo, right? Uber had to pay. This is also a big feather in the cap for trade secret law, right? They were able to show that these were true trade secrets, enough to scare Uber to settle. Yeah. Well, it's already in the public. It's in all these court proceedings. So much of this has already been publicized. There are certain parts of it that was under seal, but a lot of it got out. But yeah, whatever was not publicized, Uber is not able to use. I mean, my gosh, if they continue to misappropriate, that would be a big deal. So things that were kept under seal, they would still belong to Waymo. Gosh, I think so. Yeah. Well, yeah, he did, and I believe there are criminal investigations going on between Uber, right, for the sort of criminal espionage or corporate espionage, and it's ugly. It's pretty ugly. Yeah. Well, and yeah, it's one of those things like nobody wants him now. Like, he'll have to start his own deal, But knowledgeable dude. I don't know that much about him personally. Maybe do you know much more about his? Okay. Let's see here. Okay, just a couple more slides. Yeah.
Just to go back to the defensive patent.
Yes. Yes.
What if you defensively published in Chile or Russia?
Mm-hmm.
With that, and your competitor didn't know about it, trade office didn't know about it, or patent office, then later on you say, well, shoot, look at this white paper over in Russia.
Of course. Yeah, you can do that. Now, I mean, that's not. That's kind of weird. Why would you do that? Just a scenario.
The scenario is you don't want your competitors to really know about it, but you want to still prevent patent.
Well, so I mean, yeah. So the issue is you're saying in foreign language. Was that the idea, or foreign? Yeah. Yeah. In order to prevent the patent from getting issued, you have to. The examiner has to be privy to it. So your idea is you're kind of hiding it, so the examiner maybe doesn't find it.
Not the examiner. I mean, I give the examiner. I wish there was a way to give the examiner things confidential.
Sure.
To make it be known, demonstrate that this is actually prior art, but to do it in a way that your competitors don't necessarily recognize.
So your thought is that you would force your competitors to waste a lot of money thinking they can get a patent, then you would just invalidate it by showing them this prior art publication. I don't know. You might get some sort of like latches, like sort of like sitting on your laurels type of a thing, because I don't know. It's an interesting case. I haven't thought of that before. Very creative.
Just to give it kind of as a trade secret, but to prevent patentability in the future.
Yeah. Very interesting. I'm taking note of that myself. It's good. Smart people, man. Okay, nice. Well, okay. How do you make money with trade secrets? All right. Well, the first one is that no one knows, right? You've got this way to deliver products that no one knows how you're doing that. They can't figure it out. And the biggie is that you're able to do that for well beyond 20 years if you do it right. And that's the beauty, right? You decided on picking this method because you think you can do better than you can with patents. License and sell trade secrets. You find maybe after you've tried to exploit it, you've sold as many these golf balls. You've got this way to put this type of material together. You've tapped out your resources in your supply chain, but you've got this partner that knows how to make golf clubs, and you want to do some cross licensing. Try to make some more money. Well, you can let them in on your technology, and maybe you can come up with a way to provide a novel golf club head, or something like that. Sure.
Major League Baseball.
Okay.
Baseball. Wrong link to baseball manufacturing.
Yeah.
But to this day, nobody knows how they're actually made.
There you go.
And so there's a lot of hypothesis that the last couple of years they modified the manufacturing process. And I think Wired is when I paid for this. So what they did, they had X-rayed baseball to try to look at the composition. But they still had no idea how they manufactured it. And it's like the official baseball for the past 100 years.
Right.
And
That's cool.
Because, yeah, exactly.
That's cool.
They talk about that. They actually revise it to give it different life to it.
Yeah.
But nobody knows.
Yeah.
Nobody knows how the baseball.
That's funny, huh? I didn't hear. That's a great one.
What the composition of the actual cork is.
Exactly.
You break it apart, but then by that time you've broken what's intact in one piece of baseball.
Totally. Yeah, you can boil down the Coke liquid and figure exactly the components of each chemical, but what was the heat compound? What did they exactly? How did you get that syrup in the right proportions? And so very interesting. Yeah, so that's certainly a way they could. That Rollins may have done that, but my idea is that multiple companies can actually license and explain their trade secret, taking a risk that the company will keep it secret, right? Knowing that other company you're talking with will keep and protect it, much like you would, but you can license that and transfer it to another party, like any other right. And then potential patentability. I talked about this idea where you can keep things in-house for a long time, and then if you find out that it's still commercially viable, then seek to publish it. As long as you haven't sold it or published it, you can seek patenting on it, even if you've kept it in-house for 5-10 years. So Boeing does this all the time. They've got this Phantom Works. They've got hundreds of ideas that are currently classified as trade secrets, and they could seek patenting on them. They might not. They're kind of going waffling back and forth on whether they invest money and time and effort into them or not. That's what we do a lot of the times. We help companies figure out what do they have. Right? They've got R&D company groups that just spin their wheels all day long. A lot of times what they're doing is not aligned with where their business is going. The CEOs have no idea how to classify what they're doing. So it's just sort of like racking, filing, putting in the right priority items to go take to market. So really quick workshop here. I got another story for you guys. This is a little bit interesting one. So, okay, while working on the job at big tech, Sammy signs an NDA, non-disclosure agreement, with his boss to learn about a secret project called Neptune. It contained information about all the employees' allergies. He later decided to share the spreadsheet with a large email distribution that included vendors, suppliers, and employees to help raise awareness. Is Sammy liable for trade secret misappropriation? Yeah, well, so it's just with his boss, just within their company. For this argument, that's a great question, by the way. I assumed this would be non-disclosure between just within big tech. He's limited to distribution only within big tech.
So this design of paper is asking only remain this secretly in the company.
Yeah, just within big tech.
Suppliers, vendors, not from company, correct?
Not from, yeah, exactly. So that's okay. Okay. Do you think there is trade secret misappropriation?
It doesn't have economic value because it's
Nailed
just
it.
information about employees, about personal privacy. You probably be in a moral issues, but you can't be sued
Nailed it. Nailed it. Most people don't get that. So right. So you think, oh my gosh, this has got to be trade secret info. But no, allergies. Well, there could certainly be HIPAA violations here and probably other privacy issues. It's not economically valuable to big tech to know about employees' allergies. So there's probably a little, yeah. There could be.
But I definitely think it would be if the vendors and suppliers,
Yeah.
if those are already authorized vendors and suppliers who have their own bilateral, it's extending that family.
Mm-hmm.
So it's extending the family of who gets access to information, but in of itself, it's not necessarily a violation. It's not the general public.
Right.
The thing is about the big tech business. Big tech business is about blackmail their employees about their allergies. That will be a good because if we reveal that, we can blackmail our employees and more, and we mess our business.
That's
But-
good.
Right, but if big tech was not about that kind of business,
It's about tech.
it has economic value, but not to this company's main purpose.
And absolutely, I can easily see it as if that information is used for training their big data model, their AI, their machine learning algorithm.
There's definitely an argument for that. Yeah.
Then
Yeah. That wasn't where I was going, but yeah.
But there's a difference
Totally.
there, but
Yeah.
That could be the essence of the next generation because it is using health information
Yeah.
for tech purpose.
Mm-hmm.
Size to share the info to rate awareness.
Yeah.
About what?
Well, I mean, hey, when I wrote this, I thought of my daughters. No, my daughters have nut allergies, so maybe this employee was like, "Oh my gosh, I don't want anybody to bring nuts into the company." I mean, that's the idea, right? Raise awareness of certain allergies. That's all. But you guys spotted, you hit it around. That's one thing I wanted somebody to pick up on is that it really wasn't economically valuable, yeah, at the high level. So, one of favorite quotes from Mr. Edison is genius is 1% inspiration and 99% perspiration. So what we can yeah, right. But so you can learn all you want about the law, and it's awesome you guys are here, but it's going to take a hell of a lot of hard work to bring it to market and get these projects off the ground. But the fact that you're here has demonstrated that you're willing to do this, Thursday afternoon. So let's talk. Any questions? Yeah, man. I like to think everybody has 1% inspiration. Yes.
I have an educated question. This was brought up in a previous talk you guys gave. Is for patentability, or patents, you submit your stuff to the government and they say yes or no. If you have something that touches on national security grounds, they can say, "Oh, this is a lovely patent. We're going to put it under a file here. You have to keep your mouth shut."
Yes.
What if you, instead of patenting something like that, you have to straight screen?
Yeah. Let's go through the rules. So, not really ascertainable. Keeping it secret within the company and economically valuable. Sure.
So you could at least avoid the threat of Uncle Sam or the government saying,
Sure.
"We want such and such."
Sure. Yeah, but I mean, as soon as you went public, or as soon as you sold it.
As soon as you sold it, you can't patent it later.
No, you can. You have a full year after you sell. But I mean, I'm saying as soon as you disclose it, the government is going to find out about it. And at that point, you not only, you'd get completely stopped using, government eminent domain type of thing. They could come in and prevent you from doing anything and put you under. Oh yeah, the government has enormous powers. Yeah. And I'm not in the government, but this is all kind of through hearsay and through knowledge. Lane Gurn in law school. Yes, there's tons of authority the government has to prevent just individuals out there in the world from doing certain things. Yeah, they may not know. Well, if and until they know, right? Yeah, and there probably are rules, kind of like whistleblower type rules, for certain things, weapons of mass destruction, certain types of things that could put people at risk, nuclear, where even if your boss tells you don't tell anybody, you've got whistleblower rules. There's certain privileges where you're able to do that. I mean, that's just my thought.
Did you say once you make a trade secret public, you have 1 year to file a patent?
Yeah, you're right. So that's So assuming it's patentable, assuming it's eligible and patentable and you've not sold it or published it more than a year ago, it's eligible. This is the rule under 35 USC 101, 102A. Yeah, 102A. It's whether it's sold or published, you've got 1 year. And I mentioned earlier, even if it's a private sale, even if you're under NDA, talking with your manufacturer overseas, making it just negotiating. Hey, if you make this for me, here's what it is. If you make this for me, I'll give you a license, or I'll sell it to you. I'll license this to you for this amount. That starts the 1 year window. So no real disclosure still can start the 1 year timer. And, yeah.
So I heard the news about this, probably 1998.
Uh-huh.
Coca-Cola has a problem in Indians, their product, because this Indians reported their Coca-Cola has poisons in their drinks. So what I want to ask is
India or Native Americans?
No, India.
India, okay, yeah.
So you said the government has a really high power on that. So in the meantime, the court actually can order Coca-Cola to reveal their secret recipes to check about their poison or not.
I don't know. So you're saying that people from India were being alleged that they were being harmed by consuming beverages? Your question is whether the Indian government, the U.S. government, could demand.
They're going to investigation. They can.
I would imagine that they have the rights to do that, if they felt it necessary.
I thought that situation in India had to do with the manufacturing plant, not the consumption of the product.
Yeah, they did it at first, but yeah, it's not the case. I was just asking if the government has the right to ask a corporation to trade secret.
Well, I mean, I don't know. The answer is I don't know. Okay, I'm sorry. I haven't researched that. It's a very interesting question. I think if you're Coca-Cola, you would try to cooperate to the best of your ability without giving up that method. You tell them all the ingredients, as much as they needed. But yeah.
So David Copperfield.
Okay, the magician, yeah.
The magician.
Uh-huh.
So his case, it came to a head this past week.
Oh, really?
Where
Man, you're up on this. All right, dude. I need to talk to you. This is great.
He had to disclose the details of a trade secret, one of his trademark tricks.
Okay.
Tricks,
Wow.
in order to provide evidence that the format, the construct of the trade secret was not liable. To only obviated his liability for any damages. Only to court of public. By virtue of being court and there's not a single testimony.
Wow. Would you send me that? I'd love to look at that. That's great, man.
It came out earlier this week and I was like,
wow. Awesome. You're welcome. Take care, Keith. Yeah.
The court can
Yeah.
order it only to the court, but still private. I mean, only judges know about that.
But that's the thing was, it wasn't a direct assault against the sanctity of trade secrets. It was an obligatory disclosure in order to demonstrate that they actually did not have liability. That they took the right precautions to avoid liability until it happened.
Well, that's curious. So that's.
They kept pushing.
I'm gonna go look that up. Yeah, I gotta look at it. I gotta see. Yeah, I'll go read the case. Is it 5 or is it 6? Okay, good. Yeah, that's awesome. I'll look that up. Thank you. Great questions, man.